some of you have arbitration agreements, some of you do not. What are the pros and cons of an arbitration agreement? So the pros, first off, you have the class action waivers. And of course, that means that there will be all of the claims will be adjudicated in arbitration by the individual, and it won't be claims on behalf of the entire workforce. In assessing whether you should have an arbitration agreement, the larger the workforce, I would recommend that you do it. Implement an arbitration agreement. If smaller workforce, say below 20, below 30, the cost factor really comes into play. So if another pro is that if a plaintiff's counsel knows you have an arbitration agreement, that may very well impact his or her decision to take the case. If you have an agreement, they may opt to say, I'm not going to pursue that case. It's not worth it for me. Arbitrations have much more confidentiality than you would if you're sued in a civil court. First off, the hearing is in a conference room. It's not in a public hearing in a public courthouse. All the filings in arbitration are private and are not a public record like they would be in a court case. And of course, in selecting the arbitrator, you can select somebody, or the parties select someone who has an expertise in employment area. You never know whether the judge you're assigned in court has that employment background, or is a judge that really has no experience at all in employment and may have been in a criminal case or a courtroom or a family law department. So that's another advantage. And always the case in arbitrations, the discovery phase of the case is going to be much more streamlined, meaning it's going to be less expensive than it would be in court. Now, some people say arbitrations are faster than court. There's a different view of that, but with the backlog with COVID-19, my view is that arbitrations tend to be faster, and you'll get through the end of the proceeding than if you were in court. And plus, usually arbitrators, they'll set the hearing and on the merits, and that will be it. In court, there's continuouses all the time of the trial and other dates. So you have more certainty. Now, the cons, for now, anyway, there is a PAGA waiver, but that it may result, depending on what the California Supreme Court does, that PAGA waivers in arbitration agreements will not be enforced. And
I think we cut out.
Okay. So sorry about that. So the other cons is that there'd be a challenge by the employee, which of course costs more money. The changing laws, as you can see just from the dichotomy of, you've got the US Supreme Court, now the California Supreme Court requires regular review. And the big con on arbitrations agreement is the payment of cost. It can be, you don't pay for the judge's time in court. That's all paid by the state of California, but you do have to pay the costs for the arbitrator's time. And say in a 3-day arbitration, that could easily amount to the low end at $24,000 up to a high end of $40,000 or even more. And with arbitrations, you've got very limited appellate review. In the court system, you have appellate rights all up the way. So if you win your arbitration, that's great. But if you lose that, you're going to have a very limited ability to appeal and challenge the arbitrator's ruling.